Welcome to Narcissistic Abuse Rehab. I'm your host, M. Our topic for today is navigating child custody challenges with a narcissistic co-parent. And with us today is Derek Jacques, an award-winning attorney at the Mitten Law Firm in Michigan. Derek is renowned for his expertise in divorce and child custody cases, earning him recognition on Fox News and Michigan Lawyers Weekly for his impressive legal victories. Derek, let's begin with your number one tip for people caught up in the chaos of trying to share custody of their children with narcissistic ex-partners.
Absolutely. So I think one of the biggest things that people need to do when they're in these kind of relationships and they're trying to co-parent is they need to find some sort of structure. And the easiest solution I found is to try to have them put some kind of support team in place, whether that be family or friends, which are generally going to be supportive because they're going to realize what's been happening throughout this person's life, that they've had to dealt with a person who's manipulative, narcissistic, or has some other kind of underlying mental health issues, whether or not they're aware of these being in place or not. But having a support team in place is something that I found to be extremely important. Sometimes they may have family that they're not close with or may not have many close friends, and they actually lean back on me, and I'm able to work more as a counselor than as an attorney in certain situations. But definitely having someone that they can talk to and kind of let them know that they're not in fact doing anything wrong, that they're being manipulated or gaslighted in certain situations, I think is very helpful.
So what I hear you saying is that it's important for survivors to form alliances, to come back into society and disrupt the isolation that often goes hand in hand with this kind of abuse.
Yes, it does. And one of the other things that helps with having a support group in place is I think that a lot of these people who suffer abuse and many different forms of abuse tend to think or are led to believe that they're a cause for the problem. They don't realize that the other person is manipulated in such a way that they start to believe that the actions that are being brought upon them are because of something that they're doing. And 99% of the time, that's not true, because as anybody knows that's done any amount of research in any kind of domestic violence or abusive situations, the vast majority of them go unreported, either because the people seem to think the person's going to change their behaviors, or because they're ashamed or feel that the behaviors are brought on because of their own actions, which is just not the case.
No, it's not. Derek, I wanted to pick your brain about a landmark decision reached by the Honorable Eric S. Pitchal on June 5th. When reviewing a coercive control case at Kings County Family Court in New York, Judge Pitchal found that children are secondary victims of this insidious kind of abuse. He equated it with parental neglect. The decision was groundbreaking because there is a general lack of awareness about coercive control in our institutions. And because of this, law enforcement, social services, and the family court system can be weaponized against survivors and their children. Derek, you've litigated many cases like this. How might you advise clients to communicate clearly what their experiences of coercive control are so that agencies understand what's going on?
It's extremely difficult and unfortunate that a lot of these agencies don't believe people. But one of the things that happens in any kind of high conflict case is that people tend to use emotional abuse or other forms of abuse that are incredibly difficult to document or show that actually took place to their advantage. So a vast majority of people will allege that certain things happen during cases when they in fact don't. And what that does is that makes it more difficult for the people that actually are suffering from this kind of harm to factually be able to report it and have people believe them. So I always encourage people to have communication that takes place via some form of written communication, emails, text messages. There's parent time apps that they can use to record as much behaviors as they can, whether it's by way of putting their phone in their pocket and turning on the video mode, so at least there's audio recordings to video record interactions if they're already past the point of separation at pick up and drop offs in public locations. Michigan, you can record anything that's in public. You don't need consent as long as you're in a public area, and even if you're in a private area, if there's no reasonable expectation of privacy, you can record it as well. So they want to be able to have tangible evidence of these things happening, because there's just too many people who try to make claims that things are occurring without being able to have some kind of supportive proof. And that goes hand in hand with the courts as well. When people bring forth accusations of certain kinds of abuse or tendencies that are taking place, and you just say X, Y, and Z happened, and you don't have Exhibit A or Exhibit B to support these, it's incredibly difficult to prove to the court that something wrong is actually happening. They want to have more than just words. They want to have text messages. They want to have videos or audio clips or Ring doorbell examples showing that things were actually taking place.
Indeed, evidence is often the defining factor, assuming that it's deemed admissible by the court. Derek, I wanted to ask you about something many survivors experience in the legal system. Manipulators frequently rely on the DARVO tactic, which stands for deny, attack, reverse victim, and offender. In other words, both parties end up claiming that abuse took place. Is DARVO something you've encountered when litigating these cases?
It is. And what happens is at that point, it becomes even more difficult for the person who's being truthful to prove their point, because then there's multiple CPS cases that are being filed from each side. There's multiple police reports that are being made by different parties or even third parties at that point, because you never really know if a CPS case has been made by any specific individual. It's all private information. You just kind of believe you know who it is, and generally you're probably going to be right. But what happens is if there's multiple reports being made, I think that the agency is going to take it less and less seriously, even though that probably isn't their protocol. I can almost guarantee that's not their protocol. But when they see a lot of little complaints coming in from multiple people against each other, I think that they tend to believe that it's just a he said, she said type situation. People are going through a contentious case and they're trying to get a leg up on somebody by substantiating some sort of claim.
Yeah, and sadly, this is why DARVO is so effective. Derek, I wanted to talk to you about reactive abuse, because survivors of coercive control are often penalized for their acts of resistance to the perpetrator's aggression toward them. In other words, when a survivor stands their ground and tries to protect themselves against an aggressor, their acts of resistance and self-preservation are framed as abuse of the perpetrator, of the instigator, the manipulator, when they are in fact trying to defend themselves. From your point of view, what is the best advice you would give someone who is being accused of abuse for resisting someone's aggression?
I think, other than to document everything, because especially courts and with having less experience in dealing with CPS, because that's usually done with an individual directly rather than through their attorneys in most circumstances, unless it spirals out of control, is to keep notes, even if they're marks on a calendar that indicate something, because the more thorough you are with the notes and practices that you keep of everything that's occurred, the more believable a story is going to be. But executing a situation as quickly and as efficiently as possible, I think, is going to be the first thing that they're going to want to do, because if they can leave a situation, if they can get out of it, it's going to bolster their case and that there was something serious going on, and that's going to lead credibility, I think, down the road when the court or an agency sees that something did maybe take place when this person is forced to flee or forced to exit a situation in an expeditious manner.
So document everything. Derek, let's talk about estrangement tactics. In these cases, what legal steps might a parent take to protect and preserve their relationships with their children?
It happens somewhat infrequently, and it's looked upon fairly seriously from the court. And one of the things that we would initially look for is whether or not there needs to be an emergency order requested to be put in place by the court to restrict parenting time or put in supervised parenting time, so we can see how the person who is acting in a therapeutic setting where there's a clinician who's taking notes and is skilled in seeing parent-child interactions. Another thing that is common to do in situations like that is request that the court puts in place a guardian ad litem. And what that is that's an attorney that is placed on the case for the guidance and welfare of the children. So it's essentially an attorney that's appointed to look out for the welfare of the children. They'll conduct interviews with the parents, with the children, and then they'll usually generate a report and provide that to the court. Especially people who are true narcissists, they don't realize what they're doing, but their actions to the outside world are fairly visible when they're trying to drive a wedge between one party and a child or their children.
Yeah, and we know that there are gaps in the family courts today, which lead to systemic failures in many of these cases. But We're going to set that aside for now and explore that topic in depth in the next episode of our podcast. Derek, you successfully litigated these cases and you emphasize building alliances, forming a support network, and gathering every bit of evidence you can to document the truth of what the survivor is experiencing.
I would agree with that 100%, in that I think that based on the relationship they've been in, and the majority of the cases I do with people who exhibit these kind of tendency behaviors aren't usually short term, because they tend to pull these people back in when they try to leave multiple times. These are cases where people have either filed for divorce 1, 2, if not 3 times and gone back on it, dismissed it, where they've had custody orders put in place previously and then they rekindled their relationship for whatever reason because of manipulation, and the process starts again. So these generally aren't short-term relationships because of the manipulation that's taken place. They tend to be longer relationships with older children, unfortunately.
Yeah, and that's a reality for many survivors of coercive control. We know that on average it takes a woman 7 attempts to exit an abusive relationship once and for all, and she's never in as much danger as when she's trying to leave. Derek, considering that many of these relationships end in femicide, in your opinion, what can parents and legal professionals do when manipulators become willing to resort to extreme acts of aggression in child custody cases? How can we work toward preventing these tragedies?
I think that the first thing that you're going to have to do is make sure that you're on the same page as your client, because they're going to be generally the person with the most knowledge of what this person's behaviors are. So if you have thorough consultations with your client, if you're on the same page, if you're talking to them enough and having enough conversations, the pieces of the puzzle are going to start to align, and then you can start to ask the proper questions to see what's been happening previously, because this generally isn't something that's just going to occur during a divorce process or a custody case. It's something that's going to be long running. And if you ask the right questions and get enough information, you're going to be able to see the direction that a case is usually going to be heading right from the get-go. And people who aren't narcissistic, truly narcissistic, not people that are just alleged to be narcissistic, they're going to start to exhibit a lot of these telltale signs right from the point of separation, right from the point time that a case is filed, and they're going to be very aggressive in what they're asking for, what their demands are. Their attorneys, if they're not well versed in looking for people who exhibit these tendencies, are not necessarily going to know what's going on. And what's going to happen is you're going to have a believable client who you feel pretty bad for, and then you're going to have a completely 100% opposite side of the story from the other party. And you're going to see that right off the bat, and you're going to probably believe your client because that's what you have to do. You're going to hope that they're going to be honest with you because of attorney-client privilege and everything that goes along with that. And when you're hearing stories from the opposing counsel that are completely different about everything that's been going on, it's a pretty clear indicator that something's going on behind the closed doors that they're not wanting to share. And what they also do is it's hit or miss. Sometimes these people are very agreeable after the first hearing. If you come out very strong with what you're demanding for, what you're looking for, then they often do not want to be embarrassed. They don't want to go in front of a judge. They don't want to be told what to do. They want to hold the power. They want the upper hand. And if you notice that they're going through an attorney right away and they're trying to make fairly reasonable concessions right off the bat, that's a good sign that they don't want to proceed forward down a very, very nasty path. Some of them are the complete opposite, though, and they'd rather go to trial. There's no negotiations. Nothing's going to work. They think that they're smarter than you. They refuse to hire an attorney. And those are the ones that make things very, very messy.
One of the key points I hear you making is that it's vital for survivors to be fully transparent with their attorneys about the full extent of what's going on behind closed doors with the perpetrator so that it's possible to accurately assess the risk.
Absolutely, because they're going to know best, first and foremost, of what's going on in their life, more so than me, more so than friends or family. And a lot of times, as I mentioned, these people hide a lot of the things that have been going on in their lives, even from their closest family and friends, either because they're embarrassed or because they might think that it's going to change. A lot of times people believe that they can change other people. They think that these incidents are not going to continue to take place. narcissists are extremely manipulative in the fact that they'll do horrible things and then they'll try to rectify it by being very nice for a short period of time, and then the cycle will just continue. But nonetheless, yes, absolutely. If they're completely candid and they provide all the information, you can put the pieces together pretty quickly and see what's going on.
Derek, did your discernment of these personalities and your compassionate approach come as part of your legal training, or is it something that you acquired through experience and independent research?
I think it's something that came through experience. I didn't have any specialized legal training in dealing with narcissists or dealing with people with personality disorders. I happened to pick up a few cases with people who were pretty far out there, did some pretty crazy things, and it helped me to do a little bit more research and get a little bit more knowledge in the field. And then that kind of spiraled me picking up more cases where people were looking for attorneys who had a little bit more knowledge and dealing with these sort of individuals. And from there, it's just growing over a period of time.
Derek, thank you so much for being with us today and sharing your expertise with our listeners. If you'd like to learn more about Derek's work, log on to mittenlaw.com, where you can also contact him for divorce and child custody advice. Now it's your turn to share your thoughts about sharing custody with a narcissistic co-parent and your experiences in the family courts. I should also tell you that we've set up a Patreon account because we'd like to create weekly content to arm you with knowledge and help you on your healing journey, but we can't do it without your support. So please join our Patreon, help make this a weekly podcast. There's a link for you in the show notes, so hopefully I'll see you there. Be sure to tune in to the next episode of the Narcissistic Abuse Rehab Podcast with journalist Amy Polacko, a member of the Pulitzer Prize-winning team who broke the TWA Flight 800 story. Together, we're going to take a deep dive into how the family court system can be weaponized in child custody cases. Guys, that's it for now. Be good to yourself, and we'll talk again soon.